In 2025, the genetic data of more than 15 million people became an asset in a bankruptcy case. 10 facts explain how that was even possible. We are counting them down, and every source is on screen. Number 10 cuts against the outrage, and we are starting there on purpose because it matters. Number 10. Customers were given a window to delete their data before any sale, and many did. That single fact is the most inconvenient one for the version of the story that spreads fastest. The company published deletion instructions, and coverage in major outlets walked people through the steps. State attorneys general amplified those instructions, urging customers to act before the process advanced. So this was not data taken silently in the dark. There was notice, and there was a way out. The second inconvenient fact: the eventual buyer was a non-profit research institute, not an advertising company. That distinction is real. A non-profit research structure is not the same as selling a database to marketers. And the sale itself was approved through the bankruptcy court. This was a legal process, not a heist. We are saying all of that first because the loudest version of this story skips every word of it. There is no finding of wrongdoing here. No fraud, no crime, no charges against anyone involved. So why is the rest of this video about a serious problem? Because the problem is structural, not criminal. The question is not whether someone broke a rule. It is whether the rules were ever written for this. 15 million genomes moved through a legal process designed for warehouses, trademarks, and receivables. Nobody built that process with a human genome in mind, and that is the entire story. 9 facts left. Number 9, and it is the date this stopped being hypothetical for 15 million people. Number 9. March 23, 2025. 23andMe holding company filed for Chapter 11 bankruptcy. The filing landed in the Eastern District of Missouri, and it changed the status of one specific thing. Before that filing, your genetic data sat with a company under a privacy policy you agreed to. After that filing, it sat inside a bankruptcy estate, alongside every other asset the company owned. That is the pivot, not a hack, not a breach, a change in legal category in a single afternoon. In bankruptcy, the estate has a duty to maximize value for creditors. That duty applies to everything it holds. Which means an asset that is valuable gets marketed, and genetic data at that scale is extremely valuable. The company had reported data from more than 15 million people over its operating history. 15 million is not a customer list. It is a genetic map of a meaningful slice of a country. And genetic data has a property that no other consumer data has, which we will get to at number 4. For now, the mechanical point. Filing did not violate anyone's privacy. It reclassified it. The privacy policy people agreed to was written by a company that expected to keep existing. Almost none of those policies seriously contemplate what happens when the company simply stops. That gap is not unique to this company. It sits in most consumer privacy policies you have ever accepted. Number 8 is the moment a judge decided that gap would be resolved in favor of the sale. Number 8. Days after the filing, a judge permitted the process of selling the DNA data to move forward. This is the single most important legal fact in the entire story, and it is widely misunderstood. The court did not rule that genetic data is ordinary property forever. It allowed a process to proceed. Objections were raised. Privacy advocates and state officials pushed back during the proceedings. The process moved ahead anyway, with conditions and oversight attached, as bankruptcy processes usually do. That is the system functioning as designed. It is also the system revealing exactly what it was designed for. Bankruptcy law is built to convert assets into money for creditors quickly and predictably. It is very good at that. It was never asked to weigh whether a genome should be convertible at all. Legal analysts wrote about this in real time, asking whether genetic data can lawfully transfer this way. That question is genuinely open. Experts disagree, and no final ruling has settled it. Anyone telling you it was clearly illegal is overstating. Anyone saying it was clearly fine is also overstating. The honest answer is that the law had not decided, and a bankruptcy timeline does not wait for the law to decide. That mismatch between a deadline and an unsettled question is where the real risk lives. It is the same shape as every other story on this channel. The rules move slower than the event. Number 7 is who ultimately ended up holding the data, and the answer surprised almost everyone. Number 7. The data went to TTAM Research Institute, a nonprofit created by one of the company's own co-founders. That co-founder, and Wojcicki, had also served as the company's chief executive. Those are the facts, plainly. We are stating that without insinuation, because there is nothing in the record alleging wrongdoing in it. A founder forming a nonprofit to acquire the assets of their own bankrupt company is legally ordinary. It happens in bankruptcies across many industries, and courts examine such bids for exactly that reason. For many customers, this outcome was genuinely better than the alternative they had feared. The alternative people imagined was an insurer, an advertiser, or a foreign buyer with no obligations. A non-profit research institute with stated privacy commitments is not that. That distinction is real. So on the immediate question, who holds it now, the outcome landed softer than the headlines suggested. But here is why that does not close the story, and it is the point most coverage stopped short of. A nonprofit is an organization. Organizations change leadership, change mission, merge, and dissolve. The protection here is a commitment made by an entity, not a right attached to the data itself. Commitments can be honored for decades. They can also be revisited when circumstances change. That is not an accusation. It is a description of what a commitment is compared to a legal right. Number 6 is the number that makes that distinction matter far more than it would for any other data. Number 6, 0. That is roughly how much your genome changes over your entire lifetime. This is what makes genetic data categorically different from every other kind of personal data. A leaked password can be changed in 10 seconds. A leaked card number gets reissued in a week. A leaked address becomes obsolete when you move. Most personal data decays into harmlessness over time. Your genome does none of that. It is the same at 80 as it was at 8, and it never expires. Which means a privacy decision made in 2025 governs information that stays valid forever. And it is not only yours. Your genome contains substantial information about your siblings and your parents. And about children who have not been born yet, and who obviously consented to nothing. That is the part that has no equivalent anywhere else in privacy law. Consent that binds people who never gave it. You can delete your account. You cannot delete the fact that your relatives share most of your sequence. Researchers writing in Science described exactly this gap between existing law and genetic reality. Their conclusion was that current protections do not fully cover exploitation or misuse of this data. That is a peer-reviewed assessment, not an opinion from a comment section. Carries real weight. So the buyer being a nonprofit solves the immediate question and none of the permanent one. Number 5 is the deletion that people did, and what deletion actually accomplishes. Number 5. Deletion works with important limits, and both halves of that sentence matter. When customers requested deletion, the company committed to removing their data from its systems. That is meaningful, and people who acted during that window did materially reduce their exposure. The first limit. Some information may be retained where law requires a company to keep records. That is standard across industries and is not specific to this company or this situation. The second limit is bigger. Data already shared into research studies cannot always be pulled back. If your data contributed to an aggregated dataset, unwinding that contribution may not be possible. That is not a loophole. It is how research data works, and it was disclosed in the terms people accepted. The third limit is the one nobody can fix. Your relative's data still describes part of you. You can delete perfectly and still be substantially inferable from a cousin who never deleted anything. Which means individual deletion is a real but partial defense against a collective problem. This is the recurring shape of modern privacy. The unit of harm is a network. The unit of consent is a person. Every protection we have is built for the person. Almost none of it is built for the network. That mismatch is not a scandal. It is a design gap, and design gaps get fixed slowly, if at all. Number 4 is why this data was worth enough to be marketed in the first place. Number 4. The reason genetic data is valuable is legitimate, and understanding it changes how you read this. Large genetic datasets are genuinely useful for drug discovery and for understanding disease risk. Finding which variants associate with which conditions requires enormous numbers of genomes. 15 million is exactly the kind of scale that makes previously invisible patterns detectable. That is real scientific value, and it is why a research institute would want to preserve the dataset intact. So the buyer's stated purpose is not a cover story. Research use is the obvious and stated use. The tension is that the same properties making it scientifically valuable make it permanently sensitive. You cannot have a dataset useful enough to find disease links and harmless enough to be careless with. Those are the same dataset. The value and the risk are not separable, and pretending otherwise helps nobody. Which means the question is never whether to collect it. It is who governs it, under what rules, for how long. And in a bankruptcy, the answer to who governs it is decided on a court calendar in months. A decision with permanent consequences, made under the time pressure of an insolvency proceeding. That is the structural problem this entire video is about, stated as plainly as we can state it. Not villainy, not crime, a permanent decision routed through a process built for temporary things. Number 3 is what the states did about it, and what they were actually able to do. Number 3. State attorneys general responded quickly, and their most effective tool was a warning. They urged residents to delete their data before the bankruptcy process advanced any further. That advisory worked. Coverage was wide, deletion requests surged, and people who acted got protection. But notice what that tool actually is. It is a recommendation that individuals protect themselves. It is not a rule preventing the transfer. It is a suggestion that you exit before the transfer happens. That distinction tells you exactly how much legal authority existed to stop this. Not very much. Some states do have genetic privacy statutes, and their strength varies enormously across the country. Which means your protection in this event depended substantially on which state you happen to live in. A patchwork is what you get when technology arrives before a federal framework does. And genetic testing arrived at consumer scale roughly 2 decades before anyone wrote rules for its collapse. That is not negligence by any one legislature. It is the ordinary lag between innovation and regulation. The lag is normally harmless. Here it applied to information that cannot be reissued or expired. Which is why this case keeps being cited in policy discussions that have nothing to do with this company. It became the worked example for a question nobody had needed to answer concretely before. Number 2 is what that worked example actually established for everyone else. Number 2, the precedent. Not a legal precedent in the strict sense, but a practical one everyone can now see. It is now demonstrated that a consumer genetics company can enter insolvency and its database becomes an asset. Every other company holding sensitive biological data now operates with that pathway visible on the map. So does every investor evaluating them, and every customer deciding whether to submit a sample. That visibility is arguably the most useful thing to come out of this whole episode. Before this, the question of what happens if they go bankrupt was theoretical and easy to wave away. It is not theoretical now. There is a case, a docket, a buyer, and a documented outcome. Which means the next company writing a privacy policy has to answer it, because customers will ask. And the next legislature drafting a genetic privacy law has a concrete scenario to legislate against. That is genuinely how most privacy law gets written. Not in advance, but after a specific uncomfortable case. This is now that case, and it will be cited for a very long time. The people whose data was involved did not volunteer to become that example, which is the unfair part. They signed up to learn about their ancestry and became a case study in insolvency law instead. That gap between what people signed up for and what they got is the whole emotional core of this story. It is also the part that no amount of legal correctness makes feel acceptable, and that is a fair reaction. Both things are true. The process was lawful, and people are reasonably unsettled by it. Holding both of those at once is harder than picking one, and it is the only accurate position available. We would rather give you the harder accurate version than the easier one that spreads better. Which brings us to number 1, and it is not about this company at all. Number 1, and it applies to every service holding something about you that cannot be reissued. Number 1, the question almost nobody asks before handing over permanent data. What happens if you go bankrupt? Every privacy policy tells you what a company will do while it exists. Almost none say what happens if it stops. That omission is nearly universal, and until this case it was almost never noticed by anyone. Companies fail constantly. It is the ordinary background condition of business, not a rare disaster. So the scenario is not unlikely. It is expected, eventually, for a meaningful share of any industry. Which means for any permanent data, the bankruptcy clause is arguably the most important clause in the document. And it is usually the one nobody reads because it describes a future that feels abstract on sign-up day. That is the transferable lesson here, and it costs you nothing to apply it from now on. Before you hand over something that cannot be changed later, ask what happens to it if the company ends. If the answer is not in the policy, that absence is itself the answer you were looking for. 15 million people learned that the hard way, through a court docket they never asked to be part of. The process was legal. The buyer was a non-profit. The outcome was milder than feared. All of that is true. And the structural gap it exposed is still there, unclosed, for every company still holding data like this. That gap is the story, not a villain. A missing clause in a document nobody reads, applied to data that never expires. A missing clause in a document nobody reads, applied to the one kind of data that never expires. Did you delete yours? Tell us in the comments and tell us whether you had even heard about the window. If you work in bankruptcy law or genetic privacy, correct us. We will pin the best correction and fix it on screen. Every claim in this video is labeled verified, analysis, or contested, with the source on screen. And to be explicit one more time, no wrongdoing has been found by anyone in this case. The viral feed daily. We follow the money, and we tell you when the money is unclear. This is news analysis for educational purposes. It is not legal, medical, or financial advice. Next week, another permanent thing quietly changing hands, and this one is already in your pocket. If you made it through 22 minutes of bankruptcy procedure, you are exactly who this channel is for. Subscribe. One more time, because it is the sentence that started all of this. In 2025, the genetic data of more than 15 million people became an asset in a bankruptcy case.